If you've invented something on your own or with a small company, you probably want to protect your rights to earn money from it. Have you thought about a patent? Have you ever started preparing a patent application and found it time-consuming? If you get stuck or want assistance from the start of the patent application process, do you know how you can find acceptable help? Can your friends, family, or someone in the general public provide services to you? Who does the U.S. Patent Office work with on patent applications? I start off with the assumption that you want a U.S. patent. What help is available? Help, of course, is a broadly worded concept. When starting off with patents, you might not know what powers patents provide to owners, what processes you go through to get one, how much they cost, and perhaps most importantly, how to write and to file patents. After you file an application, what's next? If you have these perceived needs, you might talk with a friend who has gone through the process or who is otherwise knowledgeable. There isn't a problem with getting general information from friends, family, or the internet. However, there is a time when a friend, who may be an expert in patents, cannot legally help you. Since we are talking about patents, we want to know how to proceed through the whole patenting process in the U.S. There are two things to consider when seeking patent protection. The first consideration is the act of disclosing your invention to another party not involved in the development. And the second consideration is the restriction imposed by the USPTO of who can file and prosecute patents at the Patent Office. With regard to the first point, you want to be very careful about releasing information regarding your invention to others. That means keep quiet, regardless of your desire to talk about it. I don't say this because I am paranoid, or because I want to indicate that this is entirely fair, but because national and international patent law works against you if you release your information to others. If you disclose your invention, say for example at a trade show or on a blog, you may lose your patent rights. If you need to enlist the help of others, make sure they are under a non-disclosure agreement and that they do not release the information to the public. When you work with a USPTO registered patent practitioner, the only kind in the US, this is automatic and included in the ethics rules. The disclosure of your invention to patent practitioners when seeking assistance is held in confidence and is not public. Be careful though, if you disclose your independent work to your employer's lawyers, you will produce a conflict of interest for those lawyers between you and the company. They might have to disclose your invention to your employer. So, hire your own independent patent practitioner. If you are concerned with what property is yours and what property can be claimed by your employer, even if it is unfair, you will need to hire your own independent employment lawyer completely free of obligation to your company, which is something I cannot help with. I'll discuss the second point in more detail below. So what are your options? I'm going to assume you and only you are the inventor of the invention you want to protect with a U.S. patent. I'm also going to assume that you are not a USPTO registered patent practitioner, i.e., neither a patent agent nor a patent attorney. U.S. patent representation comes in one of two forms: self-representation or patent practitioner representation. The first option for going through the patent process in the U.S. is self-representation. This is only permitted for inventors when they are working on their own patent application and conducting their own prosecution. If you want to save money up front on the patent process, do everything on your own regarding the patent. Inventors can represent themselves. Inventors are allowed to interact with the U.S. Patent Office, receive communication from the Patent Office, file all papers, and process all amendments on their own behalf for their own patent applications. Inventors do not need to be USPTO registered practitioners. If a person invents something and they represent themselves, the Patent Office will receive their papers, communicate with them regarding their application, accept their amendments, and receive their petitions. The Patent Office will send all paperwork to the address that the inventor indicates in the application. There is a second option for filing and prosecuting patents. The second choice is the one the U.S. Patent Office recommends. Inventors or applicants can hire the services of a USPTO registered patent practitioner. The U.S. Patent Office controls who they work with on patent applications. All USPTO registered patent practitioners in good standing have the same power, the power of attorney, to represent inventors and applicants in all patent-related matters before the U.S. Patent Office. The patent practitioner can draft applications, file applications on behalf of others, prosecute patent applications, and file all patent amendments. If someone who is not the actual inventor is going to interact with the patent office, that person must be a USPTO registered patent practitioner. All USPTO patent practitioners' names, along with their contact information, is available online anytime at the United States Patent Office website, www.uspto.gov. Navigate to Patents and then look for a link which indicates attorneys and agents. The USPTO will not help you in the selection process. In general, you can choose anyone from this list. I'm sure that many patent practitioners, including myself, would be glad to receive inquiry from you regarding possible patent services you may need. Talk with them to see if they can provide assistance to you, as well as to discuss costs. You are not required to use someone from your state on the list, but you can if you want. The USPTO will not allow non-practitioners to represent others for patent matters. This restriction applies to lawyers, company owners, and smart friends, even if they are to own the patent from the application. Please see my video, Who Owns the Patent, for some additional information. Only USPTO registered practitioners can represent others for patents at the USPTO. The key word to note is others. There may be a few situations where one has limited powers, but these aren't important most of the time. Note that business owners cannot represent their employees unless the business owners are also registered U.S. patent practitioners. That is, business owners cannot file applications for their own companies with the exception already mentioned. Perhaps less well known, company lawyers cannot represent employees of the company for patent applications either, unless they are also registered patent practitioners. Again, regular attorneys, i.e. those who are not registered patent practitioners, are not permitted to provide assistance with patents before the U.S. Patent Office. Most attorneys already know this, but many listening to this video might not be aware of this fact. The deciding factor for filing papers and prosecuting patent applications before the U.S. Patent Office is whether or not those acts are from a person licensed by the U.S. Patent Office. Let's look at a hypothetical example. Pretend you invented an improved keyboard in your garage on your own. Let's suppose your best friend from college is an attorney, but not a patent attorney. You decide to start off on your own to save money. You begin writing the patent application. However, after a while, you become frustrated with the process. It seems like an awful lot to learn and you'd rather spend your time on other things. You ask your best friend if he can take care of this for you since he is an attorney. You'd like your attorney friend to work with the patent office since you really don't know what to do. It may seem reasonable that you should be able to choose whomever you want to represent you at the patent office. However, your attorney friend has to say that he can't do it, even though he may want to. He is not authorized with this power because he is not a USPTO registered patent practitioner. If you don't represent yourself as inventor, then you must use the services of a USPTO registered patent practitioner, agent, or attorney, which you can find as indicated earlier. If you decide to use a patent practitioner, what can you know about them in a general sense? Almost all patent practitioners have university degrees in a scientific or other technical field. You can be confident that all patent practitioners have scientific or technical training apart from law. The primary consideration to become a patent practitioner is technical expertise, not law school training. Patent practitioners have taken and passed the USPTO registration exam to practice, affectionately referred to as the patent bar exam, which covers patent law and ethics. Recall that patent practitioners take one of two forms. They are either patent attorneys or patent agents. If we were to paint with a broad brush some of the differences between these two types of patent practitioners, we could probably say the following. Patent attorneys almost certainly have a stronger familiarity with law than patent agents. And patent agents almost certainly have a deeper experience practicing their scientific and technical skills in R&D or industry as inventors or engineers and developers of technology than patent attorneys. Thus, you get different strengths and weaknesses between these two. Both offer skills which can help you. Whichever quality is most important to you will determine which you choose. Patent attorneys tend to charge higher fees. Patent attorneys often hire patent agents to write patent applications and draft claims. Both patent agents and patent attorneys have the same powers before the patent office and can fully represent inventors and applicants there. Some differences exist between these two types, but they do not pertain to practice for patent matters before the USPTO. For example, a patent attorney can provide legal counsel in court. Patent agents cannot. Patent attorneys can register trademark. Patent agents cannot. Regardless of which type you choose for your patent filing and prosecution needs, the patent practitioner will not make things up for you. The practitioner will work with you according to your instruction for your benefit as inventors and applicants. The practitioner will gather the information needed to write the application and the claims. As a further note, patent practitioners are national. They can work from any location in the world to represent clients from any location in the world before the USPTO for patents. Unlike working with standard attorneys, who must be licensed to practice in a state, patent agents and patent attorneys can represent clients from any state or from any country before the patent office. Patent practitioners do not need to be local. For example, if you are in Seattle, you can work with a patent practitioner located in San Diego. In summary, two options are available for representation for patents at the USPTO. Inventors can represent themselves and file all papers on their own behalf. Inventors or companies can hire the services from in-house or from independent registered patent practitioners to provide full representation before the patent office. Patent agents and patent attorneys are nationally licensed patent practitioners. Patent agents and patent attorneys have the same power for representing clients for patents before the U.S. Patent Office. Please read the description for additional comments.